Welcome to Steve Savant's Money, the name of the game. Hi everyone, I'm your host, Steve Savant, syndicated financial columnist and money gamer extraordinaire. Today we're talking about estate planning for the ones you love with author and estate planning expert, Mike Kilborn. Welcome to the show, Mike.
Oh, thank you.
Hey, I want to talk about Mike's book right up front that you can get at Barnes & Noble, Amazon.com, and right on the actual ULR website called disinherittheirs.com. And Mike's put together an anthology. A lot of the people say, hey, Mike, this is really heady stuff for advisors, but there's a lot of good information that a consumer can read from this.
Absolutely. I mean, I've got a glossary in the back that defines all kinds of terms that you hear every day, and you go, my goodness, what does that mean? And they can go right to the glossary and take a look at the glossary and find the answer.
This is his third edition. He's been doing this. So many advisors read this book to understand the planning tactics that we're going to talk about. Mike, let's talk about it because you keep saying, especially now, seniors. I mean, oh my gosh, Mike, you and I are baby boomers. Right. Are we seniors now? I mean,
that's scary.
It's scary.
During the next 30 to 40 years, boomers, us, are expected to pass, get this, $30 trillion to the next generation. And by the way, this is above the $12 trillion that is passing from our parents to us. So we're talking about a lot of transfer here.
Wow.
And it amazes me that 55% of the people who died last year did so without a will, without a trust, without any planning at all, and they relied on the state's document. They died intestate, and that is a terrible way. People would turn over in their graves if they knew what happens with the state's plan for their assets. So how do you get started?
Yeah.
Well, you ask, the who, what, where, when, why, and how. That's so simple. So basically you determine the size of your estate, calculate the taxes, determine who you want to get those assets, determine how you want them to get those assets, develop a plan, make it a living plan, by the way, and I'll discuss that. And don't procrastinate, because the biggest villain in estate planning is not the IRS. It's procrastination. And proper planning allows you to give what you have, to whom you want, when you want, and in the way you want, and at the same time pay the least amount of court costs, attorney fees, and estate tax as possible. Isn't that what you want? That's what I want.
All right.
So where do we start? Well, after you get all those things together that I mentioned, then I would say you want a revocable living trust, which is no big deal. You transfer assets from your name to your name as trustee of your own trust.
Now, why is that so important?
Well, it's important because, number one, it avoids probate. And there's 4 reasons, but one of them is 4 big reasons. One of them is avoiding probate. I mean, there's the cost of probate, which in some states, it ranges. In Florida, it's not too bad. That's where I'm from. 3% is the guideline for attorney's fees. 3% of your estate, up to, say, 13%, like in New York. So you say, well, geez, 13% of my estate? Yes, and so you avoid all that because there's no probate. Assets pass. The time delays, it can take months, if not years, for probate to be completed. The publicity, some salesmen make their living, some unscrupulous salesmen make their living off of reading wills and preying on families because they can see what they've got, because in some states, your probate is public. Complex, if you have more than one property, for example, in more than one state, you'll have more than one probate, so that's called ancillary probate. So now talk about time and cost delays. Woo. And then contests. Oh, you say, my kids love each other. There will never be a problem. Well, when people die, people left over change. And if you've had a death of a parent, you may know this already. But having a revocable living trust avoids all that question of probate. You can still have a lawsuit, but it wouldn't be the same as contesting a probate process.
And I am so sorry to say, but I've seen a lot of sibling rivalry after mom and dad's death, and it causes huge pain.
It does.
Huge pain.
And setting up, the way you set your trust up, like for example, leaving assets in a trust to a single trust for more than one child can be a big mistake. It's better maybe to divide it into separate trusts and maybe let them be the trustee of their own separate share. And there's a reason for that, and I'll get to that. But then there's incapacitation. Now that's a bigger reason to set up a revocable living trust, because you're 6 times more likely to become incapacitated than for you to die in the next year. So what happens? Well, if you have something called a durable power of attorney, and you probably do, but if you don't, then without a revocable trust, you've got to have your spouse or somebody go to court, get permission to spend your money, etc. With a trust, you spell out exactly what you want to happen. So this is a very major reason to have a trust. There's a tax benefit to it, possibly using what's called the A/B trust planning, but we have this new portability of your exemption to your spouse without using the old bypass trust to make sure you used your exemption. I won't go into detail on that. It's in my book, but there is a benefit. And you could use a will. You could do it with a will, but it's better done with a trust. But here's a big one. This is the fourth big reason, and that is you can protect your heirs in a way they can't do for themselves. And what I mean by that is, I think that nobody should leave anything of any consequence to anybody outright. You should leave it in trust. Now, you might have 3 kids, so let's say you've got 3 kids. Then you have 3 separate trusts. And make them the trustee of their own share, unless they're a spendthrift. And if you want, you can make a co-trustee with them and so let them choose them and be able to fire them and rehire another. But by doing so, they have control of what they have. And they can have the income from their trust and the principal if they need it for health, education, maintenance, and support, which is virtually everything. Technically, they're not supposed to be able to go to Las Vegas and put it on the dice table, but they could even get away with that. So people say, well, Mike, why bother with a trust? And here's the answer. Whatever's in trust is free from the claims of creditors, free from predators, and free from divorce. And if we did it right, and they don't spend it all during their lifetime, whatever's left over will go on to their heirs, your grandchildren perhaps, without another layer of tax in their estate. I mean, what could be more powerful? Why would you leave anything outright if what I just said was true? You wouldn't. So look at your plan and maybe consider making a change.
When we come back from the break, we're going to continue on some of the estate planning ideas and some of the good things you just went through. That was a great list. Right after the break. It's not how much money you make, it's how much money you keep. And keeping more of your money is even harder these days with high taxes, fund expenses, and fees for financial advice. And when you consider the uncertainty of the market and the rising cost of living, the purchasing power of your dollar is constantly at risk. But a tax-deferred annuity with an inflation rider can be the most cost-effective way to generate increasing annual income without market volatility. For more information on how annuities may work for you, just email me at steve@thenameofthegame.tv and ask for our free annuity information. Well, welcome back to our second segment with Mike Kilborn, CLU, CHFC. You say, Steve, what are those? Those are credentials that we use in our industry to identify people who are charter financial consultants as well as charter life underwriters. And it's important sometimes to look at that advice because we're giving a lot of information. You say, Steve, I don't know how I'm going to keep this straight. You want to get an advisor. And Mike is an actual instructor via his platform speaking and his book, Disinherit the IRS, which you can find on that exact address, disinherittheirs.com. You can buy it at Barnes & Noble as well as Amazon.com. Everything in here is just power-packed, and it's really good information, and most of this is pretty readable. You'd think, well, I have to be deep. But the vocabulary and the glossary in the background are just really, in the back of the book, are really helpful. And if you forget, oh, I forgot what he said, what does that mean? You can go right back there. It's a great tutorial, great basic idea.
Yeah, don't die till you read this book.
Don't die till you read, that's true. Now, walk me through some of the basic planning documents here.
All right. Well, in the previous session, we talked about a revocable living trust, which I think everyone should have. We talked about how important it was and how you should leave things in trust through your living trust, which is your will. It becomes your will. And so now you say, well, Michael, if that's true, the next document I'm going to suggest that you have is something called a pour-over will. And you're going to say, well, why? You just said that the trust is my will. Well, let's suppose you forgot to put something in the trust. Unfortunately, that will have to go through probate. And the pour over, that's what it says. It'll tell the probate court, pour it over into the trust. And because the trust is your will, it's your loving instructions. But if you properly fund your trust, you won't, the pour over will isn't needed. You can, when you die, no one will even look at it because everything's properly funded in your revocable trust and there's no probate. Another document that's very important is a durable power of attorney. Well, again, a revocable living trust pretty much handles that because when a durable power of attorney works while you're alive, but you're incapacitated, let's say. Well, if you're incapacitated, your alternate trustee, maybe your spouse, takes over and handles things. But suppose you left something out of your revocable living trust. It sits out here, and it's still in your name. Well, with a durable power of attorney, or maybe you can call a special power of attorney that is just for funding, and it allows your spouse to, just for funding, to fund it into your trust because now your spouse is in charge of things because you're incapacitated, and now everything's in your trust, and should you die, it's all handled. There will be no probate. So having a durable power of attorney is the third of the three documents. Revocable living trust, pour-over will, durable power of attorney, and then you want a living will, in my opinion, because it specifies whether you would like to be kept on artificial support or you want to pull the plug. I mean, my father-in-law, he had a terrible stroke and he was brain dead, and his family, after a few days, he was on a machine and probably would have lasted for a long time, but they made the decision to pull the plug because it was just a waste, and he died a natural death about 24 hours later. A living will is an important document. And then there's a healthcare surrogate. And that's what we call it in Florida, but it's also called a healthcare power of attorney. And everybody wants that because if you can't make the decision for a healthcare decision, you've got to have someone to make that decision for you. And so you oftentimes give that to your spouse or family members to help make those healthcare decisions. That is a very important document, and you want to make sure you have that. And usually, when the attorneys do the revocable living trust, they almost automatically go to those documents. And the last one is HIPAA form. HIPAA is, you often hear it's a tax law, it's an authorization form that many of us sign at our doctors to allow our doctor to release our medical records. But what about releasing records to your family in case you're in the hospital and they've got to call another city to get those documents? Well, if you have a HIPAA form, sometimes built into your healthcare surrogate, healthcare power of attorney, that allows your spouse, for example, to get those documents to the right doctor. So you want to have that built in, a HIPAA form.
Mike, I've got a question. If I did these 6 that you said, I mean, this is basic foundational thinking. It really lets you and allows you to dictate all the wishes and desires that you have.
Yes.
What am I looking at on a cost mostly? This is a lot of attorney information docs, but what kind of numbers am I looking at?
Well, in other words, your form, that's a good question. And I hate quoting attorneys' fees, but typically per individual, for 2 individuals might be $3,500. If you were doing it alone, it might be a couple $1,000s. And think about how small that is compared to the probate process. I said 3 to 13% of your estate compared to spending maybe $2,000 for a living trust, maybe $3,500, $4,000 for an attorney to do a good job. Maybe it's $5,000. That's chicken feed compared to the savings that you would have.
And of course, so your big premise is many times people sit there and they procrastinate on this, and we think the IRS is the villain here, and it's not the IRS. We can help defeat that. Our problem is that my consumers are thinking in their mind, I'll just put it off. I'll do it tomorrow.
Oh my God, procrastination. The biggest villain in estate planning is not the IRS. It's procrastination. Now, just so you know, you need to make sure the members of your team to help you put this plan together as an attorney, typically, and look for one that specializes in estate planning. Not someone that has it as an ancillary to their regular law practice, but someone that specializes. And typically, large law firms always have someone that specializes. And you want a CPA in the formula, your CPA, and of course you want a financial planner if you can have it. Bring in a financial planner, preferably someone that has the right designations, like a CHFC, CFP, Certified Financial Planner, Chartered Financial Consultant, and then, of course, there's CLU, Chartered Life Underwriter. Those are the key designations to look for. But for sure, don't procrastinate.
Again, remember, you can get Mike's book, Disinherit the IRS, on disinherittheirs.com, Barnes & Noble, and Amazon.com. Well, that's our show for today. I want to thank Mike Kilborn for being my special guest and today's money mentor. And before moving forward with any of the ideas on our show, always consult your tax advisor and your legal counsel. And as the good Reverend John Wesley once said, make all you can, save all you can, give all you can. I'm Steve Savant. We'll see you next week.